Hello everyone. Part 2nd Citizenship Article 5 to 11. In this video, we will know about citizenship. Provisions for citizenship are given in Articles 5 to 11 in Part 2nd of the Constitution of India. We will discuss all 7 articles and provisions given in the Citizenship Act 1955. The Citizenship Act 1955 deals with matters relating to acquisition, termination, and determination of Indian citizenship after 26 January 1950. Citizenship provides definite rights, duties, privileges, and obligations that do not belong to aliens, foreigners. The Constitution of India provides a single citizenship for the whole of India, but the USA citizens hold double citizenship because they are the citizens of whole USA and citizens of respective states. The Constitution of India does not provide a detailed or comprehensive provisions regarding citizenship in India. Article 5 to 11 describe classes of persons who could be considered the citizen of India at the time of commencement of the Constitution. That is on 26 January 1950. The Constitution leaves everything about the citizenship to be regulated by law made by Parliament. All public or government offices are open to a citizen of India. A citizen is eligible for recruitment, selection to all public government services. The right to vote and certain fundamental rights are available only to citizens, and citizens have some obligations, duties like paying tax, defending the country. Before 26 November 1949, there was no concept of Indian citizenship. Before the adoption of Constitution, we lived in British India and we were under the crown and we were British subject, that is Praja, not the citizens. The partition of India and huge migration created many big problems for citizenship decisions. The Constitution only tells about who would be citizen of India at the time of commencement of the Constitution. The Constitution did not provide the mode or method of acquisition and termination of citizenship. Article 11 said that Parliament could regulate the right of citizenship by law. Therefore, the Indian Citizenship Act passed in 1955 for acquisition and termination of citizenship. Now, we are going to discuss articles one by one. Article 5, Citizenship at the commencement of Constitution. Article 5 said that at the commencement of this Constitution, every person who has his domicile in the territory of India and who has born in the territory of India, or either of whose parents was born in the territory of India, or who has been ordinarily resident in the territory of India for not less than 5 years immediately preceding such commencement shall be a citizen of India. The term domicile used in this article is an important criterion for citizenship of any country. Domicile ordinarily means a person's residence where he intends to live on a permanent basis, thus a permanent resident and the intention to reside indefinitely are two important factors of domicile. Article 6, Rights of citizenship of certain persons who have migrated to India from Pakistan. According to Article 6, a person who has migrated to the territory of India from the territory of Pakistan shall be deemed to be a citizen of India at the commencement of this constitution if he or either of his parents or any of his grandparents was born in India as defined in the Government of India Act 1935, and in the case of where such person has so migrated before the 19th day of July 1948, he has been ordinarily resident in the territory of India since the date of his migration, or in the case where such person has so migrated on or after the 19th day of July 1948, he has been registered as a citizen of India by an officer appointed by Government of India. But in the case no person shall be so registered unless he has been residing in India for at least 6 months immediately preceding the date of his application. In Shanno Devi versus Mangal Sen case 1961, the Supreme Court had held that the word migrated in Article 6 was used in the narrow sense to mean coming from one place to another with the intention of residing permanently. In Kolathil versus Kerala case 1966, the Supreme Court overruled its earlier judgment and held that word migrated was used in the wider sense to mean coming from one place to another. Article 7, Rights of Citizenship of Certain Migrants to Pakistan. According to Article 7, a person who has after the 1st March 1947 migrated from the territory of India to the territory of Pakistan shall not be deemed to be a citizen of India. But Article 7 makes special provisions regarding the citizenship right of the person who migrated to Pakistan after 1st March 1947 but returned to India subsequently. An exception has been made in the case of those returning to India on the basis of permits for resettlement in India. Such person became entitled to be citizens of India if they fulfilled the condition provided under Article 6. Article 8, Rights of Citizenship of Certain Person of Indian origin residing outside India. Several persons of Indian origin have been residing in foreign countries for purpose of employment, etc. Therefore, the founding fathers have made many provisions in the Constitution to protect the citizenship rights of such person in India. Article 8 provides that any person who or either of whose parents or grandparents who was born in India and who is residing in any country outside India shall be deemed to be a citizen of India if he has been registered as an Indian citizen by the diplomatic or consular representatives of India in that country on an application made by him to such diplomatic or consular representative whether before or after the commencement of constitution. Thus Article 8 takes care of the future citizenship needs of all Indians residing abroad. Article 9, person voluntarily acquiring citizenship of a foreign state not to be citizens. Article 9 provides that if a person has acquired the citizenship of a foreign state or country, he shall forfeit or lose the rights of citizenship of India. While this was applicable to cases arising before the commencement of the Constitution, the cases arising after the commencement were to be dealt with the provisions of the Citizenship Act 1955. It has been held by the Supreme Court that the question whether a person has lost the citizenship of India on acquiring the citizenship of another country has to be determined or decided by the government of India. Article 10 Continuance of the rights of citizenship. Article 10 says that every person who is a citizen or deemed to be a citizen of India under any of the provisions in Articles 5 to 10 shall continue to be a citizen of India subject to the provisions of any law made by Parliament. In the other words, it means that the right of citizenship cannot be taken away from a citizen except through parliamentary provisions. The term every person used in Article 5 and 10 has been interpreted to cover persons who may be in jail under the trial or who may be undergoing imprisonment. Members of armed forces are also included, but the Citizenship Act 1955 made it clear that corporations were not citizens. The Supreme Court also said that the corporation could not claim rights under Article 19, which were for citizens only. Article 11 Parliament to regulate the right of citizenship by law. Article 11 says that Parliament has unfettered or unrestricted powers for enacting or making laws relating to the acquisition and termination of the citizenship of India and all matters connected therewith. Parliament therefore passed the Citizenship Act 1955 and all matters relating to the citizenship rights after the commencement of the Constitution are to be dealt with its provisions. The Act was amended in 1986 to tackle the situation created by the large scale unlawful immigration into India of persons from Bangladesh, Sri Lanka, and some African countries. Now we will know the Citizenship Act 1955 and its provisions. The Citizenship Act 1955. The Act made detailed provisions for acquisition of Indian citizenship by birth, descent, registration, naturalization, or through incorporation of territory. Similarly, it provides provisions for termination or loss of citizenship by way of renunciation, voluntary acquisition of citizenship of another country, or through compulsory deprivation by the government of India on certain grounds or basis. The Act also made specific provisions regarding Commonwealth citizenship. A citizenship of a Commonwealth country would have the status of a Commonwealth citizen in India. Government could make suitable provisions for it. In short, the Citizenship Act 1955 provides for the acquisition of Indian citizenship in 5 ways. First, by birth. A person born in India after 26 January 1950 would be a citizen of India by birth. Second, by descent. Anyone born outside India after 26 January 1950 would be a citizen of India if his father was an Indian citizen at the time of his birth. Third, by registration. Any person who is not a citizen of India under certain conditions could acquire Indian citizenship by registration in the prescribed manner. Fourth, by naturalization. A foreigner could acquire Indian citizenship on application for naturalization on certain conditions. Fifth, by corporation of territory. If any territory became a part of India, the government of India shall notify the person of that territory to be citizen of India. The Citizenship Act 1955 lays down the three modes or ways by which an Indian citizen may lose his citizenship on certain grounds. They are renunciation, termination, and deprivation. First, renunciation. It is a voluntary act by which an Indian citizen can give up Indian citizenship. Second, termination. It takes place by operation of law when an Indian citizen voluntarily acquires the citizenship of another country. He automatically ceases to be an Indian citizen. Third, deprivation. It is a compulsory termination of the citizenship obtained by registration or naturalization. The citizenship is deprived on the basis of a government order if citizenship is acquired by fraud or being disloyal to the constitution, etc. The Citizenship Act 1955 has been amended 6 times so far by the Citizenship Amendment Acts of 1986, 1992, 2003, 2005, 2015, and 2019. The most fundamental changes came in 2003 and 2005 under Amendment Acts of 2003 and 2005. Provisions have been made for maintenance of a national register of Indian citizens and for overseas citizenship of India. A person of Indian origin may be registered as an overseas citizen of India by the government of India and given some rights like owning property, traveling to India without visa, making investment in business, etc. However, overseas citizens shall not be given the right to vote or to be a candidate and can not be appointed as judge or public services, etc. The Citizenship Amendment Act CAA. The Citizenship Act 1955 was amended sixth time recently in 2019 by the Citizenship Amendment Bill 2019, which was passed by the Parliament on 11 December 2019 and the President signed it on 12th December 2019. The amended act makes foreign immigrants of 6 religious communities, that is Hindu, Sikh, Jain, Buddhist, Parsi, and Christian from Afghanistan, Pakistan, and Bangladesh, eligible for Indian citizenship. It is applicable to those who have taken shelter or refuge in India due to persecution on the basis of religion or fear in their countries and have entered into India on or before 31st December 2014. The provisions of the Act do not apply to tribal areas of Assam, Meghalaya, Mizoram, and Tripura, and the areas where the inner line permit is applicable, including the states of Arunachal Pradesh, Nagaland, Mizoram, and Manipur. It is important to remember that the constitution makers decided to provide a single citizenship with the aim of building an integrated Indian nation and a united fraternity. All citizens have the same rights and duties all over the country without any discrimination. It is all about the citizenship provisions in India. We have already discussed part 1 of the Constitution in previous video. In next video, we will discuss fundamental rights. Till then, keep learning to be an aware and good citizen. And at last, if you think our work motivated you to do like us, please do so. Thanks.